All right, and I do apologize for the appearance of the screen. In addition to streaming from outside of the county, I'm using a different laptop because my court laptop has a cracked screen. So with that, Ms. Kyler Green, would you please begin the announcements?
Yes, good morning. Emily Kyler Green, attorney for the department.
On a PAL permanency specialist with Belong.
Christy Cannot, permanency supervisor with Belong.
Richard Saldivar, attorney for the mother, Connie Ramirez. Ms. Ramirez, will you unmute and announce, please?
Connie Ramirez, I'm the boy's mom.
Rochelle Acevedo for Father Ramsey Ramirez. Mr. Ramirez, can you please announce?
Ramsey Ramirez.
Jennifer Harris, attorney for the father, Mr. Velasquez. Mr. Velasquez, please unmute and say your name.
Anthony Velasquez.
Irene Acosta, attorney for the children. And Your Honor, I'm announcing not ready. There was some information that was given to the parties on Friday, and I haven't had the opportunity to investigate the allegations on my own, so I'm requesting a reset so that I'm able to do so.
Jill Roden, Tri-County CASA.
Thank you. Okay, we've had a not ready announcement from Ms. Acosta. Ms. Acosta, you stated that there's new information available to the parties and that you need to do an investigation. Does it revolve around the facts and circumstances that would affect your decision in either one of the motions that's set for today?
Yes, Your Honor, it does. It's regarding the children, and without going into what the allegations are, I just need to speak with the children and speak to other people close to the children to figure out what exactly is going on.
And you believe that this information could potentially affect your decision on whether or not you agree or disagree with either of the motions?
Yes, Your Honor.
You believe it's in the best interest of the children for you to have the time to talk to them before we go forward with these?
Yes, Your Honor, I do.
Ms. Kyler Green, what is your response to Ms. Acosta's not ready?
Your Honor, the department does not have an objection. We also think that it's important that Ms. Acosta be able to speak to the children so that she can offer the advice that she's given from them.
Okay. Mr. Saldivar?
Judge, I believe my client would like to move forward today. She wants a decision on her motion for placement. I understand that Ms. Acosta needs to speak with the children. This motion's been on file since last month, Judge, and I do agree that we just received information late Friday, so I understand why she may have not had the opportunity to speak with the children. But I believe my client would like to go forward today.
Ms. Acevedo?
Judge, I would announce ready, and same argument as Mr. Saldivar, Judge. I believe our motions were filed at the same time, so we've been waiting to have this hearing for almost a month, Judge. I anticipate my client would like to move forward. I did let him know that that this new information did arise late Friday. So I certainly understand the position of the ad litem, but I believe he'd like to move forward today.
Harris?
Your Honor, my client is in support of one of the motions. However, we have no objection to resetting.
Casa?
We have no objection to resetting. We have been able to speak with some of the parties close to the children since Friday, but we also have not had a chance to speak directly to the children. So we would utilize the time if the court reset to actually speak directly to the children as well.
Well, I think that if the ad litem and the CASA advocate and the department all feel as if this information is pertinent to the case, as the court, the gatekeeper of the evidence, that's something that I would like to see too. I want to know that the advocates for the children are advocating based on current information. And we've got two motions. One is a motion for monitor to return, and the other one is an authorization to place. Those are very significant motions. And I think that if there's new information and we've got parties who are not aware of all the information, then I'm not going to get the evidence that I'm looking for, that I really want, that's updated. So as much as I hate resetting things that have been on the docket for a while, it would be kind of silly to go forward if we've got new evidence that's pertinent to the case and it's material to the case. So I'm going to go ahead and grant the reset. Find that it's in the best interest of the children for the reset to be granted so that the court has all the updated evidence by the time I'm requested to make decisions on these motions. So we're going to reset the next available date I have for the time announcement on this case. It is February the 1st at 11:30. I'm also going to order the parties to meet again prior to that hearing. I want Ms. Acosta and Casa to interview the children as they have requested. And I want all the parties to share whatever information you have. So when we come back on the 1st, everybody's ready to go and everybody knows what they need to know. I want updated information, but the parents do have a right to have their requests heard, and I want to make sure that they get that right granted on February 1st. So let's be prepared. Okay. Anything else that we need to take up today?
Judge, can I have a brief breakout room with Ms. Ramirez? It's not related to this case, but I just need to speak with her after the hearing.
Okay, that's fine. All right, then I'll see you all back February 1st, 2024 at 11:30. Nothing further, all parties are excused.
Thank you.
Thank you, Judge.
All right, with that, Ms. Kyler Green, would you please begin the announcements?
Yes, Emily Kyler Green, attorney for the department.
Carly Sherrod Buckner, permanency specialist for the case.
Christy Knott, permanency supervisor with Belong.
Irene Acosta, attorney for the mother.
You're muted, Ms. Fuller.
Deborah Fuller, attorney and guardian ad litem for the child. I'm ready, Your Honor.
Jill Roden, Tri-County Casa.
Right. Let me have a little bench conference with the attorneys really quick. Then we're going to go back on the record and we will recommence the trial that we began on January the 9th. And if there's no other housekeeping issues at this time, Ms. Kyler Green, you may continue questioning Ms. Sherrod Buckner.
Thank you, Your Honor. Good morning, Ms. Sherrod Buckner. When we broke last time, you had begun talking about the psychological evaluation services that were ordered for Ms. Hilburn. Can you please discuss what she was ordered?
Yes, ma'am. Within the psychological that was conducted, the recommendations from the psychological, it included that she would benefit from trauma-informed individual psychotherapy that would help her develop insight and receive emotional support to improve her interpersonal functioning. It was also reported that she would benefit from continued medication management per the psychological, and then they wanted her to also do occupational therapy, where they said that she would benefit from the DARS program that would help her seek employment and also any medical needs that need to be addressed. Also, they did.
Go ahead.
Also, in the psychological, it said that if she does not address the concerns, then Misty could also be prone to have more situation with DFPS.
Okay. To your knowledge, were any of those recommendations followed?
From the psychological, no, ma'am.
Okay. Did you reach out to Ms. Hilburn to ensure that she understood the recommendations?
Yes, ma'am. When we had our meeting in June, I also talked to her about the psychological.
Okay. And so, to your knowledge, was she aware of these recommendations and that they were ordered to be followed?
Yes, ma'am.
Okay. Let's discuss parenting. What was ordered in regards to her parenting skills?
So with the parenting, she was ordered to complete parenting classes through Essay for Fatherhood, which is an 8-week course. Depending on if the client missed, then they have to do an additional 6 to 8 weeks.
Okay. Did she complete any of those classes?
So per Essay for Fatherhood, she did attend 3 sessions, but they also allowed her to make up a class due to the 4th of July weekend. So she only completed 4, but due to the fact that she did not complete the whole program, she was discharged.
When you say she was discharged, is that successfully or unsuccessfully?
Unsuccessfully.
Okay, and were you able to review that documentation that informs Belong that she was discharged unsuccessfully?
Yes, and I also sent Miss Missy the email that is sent to me when a client is discharged.
Okay, and so were you able to discuss with Miss Hilburn about that?
Yes, ma'am.
And does she have an understanding that she had more classes to take?
Correct.
Okay, did she acknowledge to you whether she intended to, or what was that conversation like?
So I did explain to her, because she was just saying that she was attending the classes, and I explained to her every week, either Wednesday, Monday, or Wednesday, when she do attend a class, I get the confirmation for that particular class that she attended. I did explain to her that she needed to call her instructor to kind of figure out if she was able to kind of make up some of the classes that she wasn't attending. But according to her, she was attending. But from the emails that I received, she wasn't going.
Okay. Do you feel that you made every effort possible to ensure that she understood that these classes needed to be attended?
Yes. And that
Okay.
she also engage as far as like participation and talk and things like that.
Okay. Do you feel like there were any other efforts you could have done in regard to ensuring that she was able to complete the parenting classes that were ordered?
No, ma'am, because the class is pretty much self-paced. Sorry.
Okay. Did she indicate to you any difficulty in attending these classes, technical difficulties or trouble getting there, anything like that?
No, ma'am, it's virtual.
Okay. What about parent-child visits? That was also ordered to occur between Ms. Hilburn and her child. Is that right?
Yes.
Okay. Did she attend those visits?
Yes.
Were they appropriate?
Yes, ma'am. So I am the one that started to supervise the visits in the beginning until they had been taken over by Children Matter.
When was the last time that she had an actual observable parent-child visit?
June 3rd of 2023.
To your knowledge, was Ms. Hilburn continuing to have outside conversations with Morgan?
Yes.
And were those allowed by Belong?
No, ma'am.
Okay. What about employment and housing?
According to Ms. Hilburn, she said she did not work, and then she also did not have housing. She was actually staying with friends.
Okay. Were you able to ever assess during this entire case any available place of housing that Ms. Hilburn would have had for Morgan?
No, ma'am.
And did you ask?
I did. So when I do my monthly visits with her, they was usually met at a friend's house, which I did ask her if I'm able to come in to see the residents. But the only thing I've got from Ms. Hilburn in text message and things, she just said, I never said that Morgan was coming to stay with me. And then she also didn't want her friends involved in the case.
Did Ms. Hilburn ever reach out to you to request any knowledge of Morgan's well-being?
In the beginning, yes, but it wasn't consistent.
To your knowledge, is she able to care for Morgan financially?
No, ma'am.
And what is the reason for that?
So with Ms. Hilburn, I did tell her that she still needed to have employment. And then with those employment, I would need to get a work schedule, and also she would need to provide me with her paycheck stub. So, and I did explain to her if she did have income coming in, I wanted to kind of see that, because I did explain to her while she was doing her parent-child visit, she also wanted to start providing for Morgan, whether that be clothes, anything that was deemed about placement that Morgan needed. I know she was just saying that at that particular time, she did not have any funds. It was just be friends giving her money.
In your experience with this case, has the contact that Ms. Hilburn has had with Morgan, has it been in Morgan's best interest?
No, ma'am.
Why?
I know with the conversations with Mom and Morgan, it's just more of there are a lot of laughing, joking. According to Morgan, they don't really talk about a lot of serious things.
Objection, hearsay.
So without going, I'll rephrase, Your Honor. Without going into the specifics of what Morgan has told you, based on your knowledge of this case, why are you concerned that the conversations are not in her best interest, just based on your knowledge and work as a caseworker?
I know since I've been assigned the case, I know that with the concerns that we have, that Mom still have not addressed the reason for the case, which also include her parenting. I do believe that as far as the contact with Mom, it has not been appropriate due to the fact that the things that I have seen that goes along with Morgan's behavior is not stable after she has spoken to Mom.
Morgan ran away in this case, right?
Correct.
Okay, and was her mother privy to that information?
Correct.
So throughout the course of this case, has there been problematic actions from Ms. Hilburn in regards to maintaining Morgan's safety?
Yes, ma'am.
Okay, so based on the mother's inability or non-compliance with the court-ordered services, do you find that it's within Morgan's best interest for her parental rights to be terminated based on the fact that she has not completed those services, but also that it's within Morgan's best interest?
Correct.
And what's the permanency goal for Morgan at this time?
I do believe we have it as relative adoption.
And is that an achievable goal if Mom still has her parental rights?
No, ma'am.
Okay. Thank you, Your Honor. I have no further questions.
Ms. Acosta.
Thank you, Your Honor. Ms. Buckner, with regard to Mom's services, you mentioned that she had been engaged in individual counseling with Shonda as far as that correct?
That is correct.
Okay, and that she completed a psychological?
Yes, ma'am.
Okay. And that she was engaged in parenting classes?
Yes, ma'am.
What other services was she supposed to complete?
I know with Ms. Hilborn, we did ask her to complete a hair test that was court ordered that I did schedule for her numerous times that she has yet to complete. Due to her individual counseling, she did not successfully complete, so she was unsuccessfully discharged from individual counseling. I do know that she also still needs to complete parenting due to the fact that she was also unsuccessfully discharged from the essay for fatherhood. And then also, Mom will still need to show proof of employment and then also housing as well to show that she's able to provide a safe and stable living environment for Morgan. And then I know that Ms. Hilborn also have to show me proof that she has completed a psych eval that I have yet to speak to her about.
I'm sorry, you said a psych eval?
Yes, ma'am.
Were all of the referrals sent out for her services?
Yes, ma'am.
And when did you give Mrs. Hilburn the information regarding the referrals?
So with that, I did complete the FSNA, I do believe back in August. I do believe April. And so once she's able to sign the release of information, which she did sign in April, that's when I'm able to send out 2054 office, which is our service authorization. So when I had the meeting with mom in April, that's when we discussed all of her services, and she requested for them to be virtual. So all of her services were virtual.
At any point, did you have any knowledge about whether or not the mother was having difficulties obtaining her services virtually?
Can you rephrase the question, please?
Have you ever had any knowledge about whether or not the mother had difficulty accessing her services virtually?
No, ma'am. Not that I can remember, no, ma'am.
Okay. Have you had difficulty contacting Ms. Hilburn?
Yes, ma'am.
Okay. Have you ever had any indication during this case that there were communication issues with mom that could potentially be a barrier to her doing her services virtually?
I've had issues with communicating with mom, but I'm not for sure if she had any issues contacting her service provider to engage in those services.
Okay. Given that mom has had, in your words, unstable financial situation, is it unheard of to think that she might have had difficulty communicating with her providers virtually if she was having issues with a phone or with a way to communicate with those providers?
I'm not for sure what you're asking. I apologize.
Has the mother had any issues being able to communicate with the parties in this case because of her phone or computer or communication issues?
Not that I'm aware.
Okay, but you did testify that you've had issues communicating with mom, correct? And being able to get a hold of her?
Correct.
Okay. You mentioned earlier that Morgan had previously run away, correct?
Yes, ma'am.
Okay, and isn't it true that at least on one or more than one instance, Mrs. Hilburn did in fact tell Belong that Morgan had run away, and she did tell you where she was? Is that correct?
That is correct.
Okay, and isn't it also true that Morgan later confirmed that the information the mother had given was correct?
That is correct.
Okay.
Excuse me, Ms. Sherrod Buckner, this is the court reporter. Can you lower your camera so that we can see your face a little bit more? I just want to see your mouth too. Thank you.
You also testified that the visits between Morgan and her mother, they were laughing and joking around. Is that correct?
Correct.
Okay, but isn't it appropriate for a mother and a child to be laughing and joking around? Isn't that, an indication of a good visit and a healthy relationship between a parent and a child?
Correct.
Okay, so the visits were going well.
Yes, ma'am. From the ones that I did observe, yes, ma'am.
Okay, and to your knowledge, doesn't Morgan want a relationship with her mother? Doesn't she reach out to her?
Morgan does have phone conversation with her mother currently now and placement.
Okay. And to your knowledge, she reaches out to her mother, correct?
On her own, yes, ma'am.
Okay. And isn't it also true that in this particular case, that Morgan wasn't removed from her mother's care, correct?
That is correct for this particular case.
Okay. I'll pass the witness, Judge.
Fuller.
Ms. Sherrod Buckner, in regards to this case, when was Morgan removed?
Morgan was actually removed back in March of 2023.
Okay, so it's been more than 9 months since she was placed in the care of the department, correct?
Correct.
But she was previously removed from her mother in another CPS case, correct?
Correct.
And that was due to her mother's drug use and instability, correct?
Your Honor, I would object to hearsay. Ms. Curly Sherrod-Buckner doesn't have personal knowledge of the reasons for removal in prior cases.
And Your Honor, she is the custodian of record. Once she takes over this case, she has the ability to read the previous case, and it was also in the affidavit of removal when this case was filed.
Unless you want to take her on board dire, Ms. Acosta, I'm inclined to overrule the objection. I guess she doesn't want to take her on board either. See if she comes right back.
Okay.
Okay. I don't know if you heard me, but I said it. If you don't want to take Ms. Sherrod-Buckner on board dire as to what she knows about that previous removal and how she would know it, then I'm inclined to overrule your objection.
I'll take her on board dire, Judge. Ms. Sherrod-Buckner, were you personally involved in any prior removals of Morgan?
No, ma'am.
So any testimony that you would give is based off of information that you would be getting from, where would you be getting that information from?
It would be actually the removal affidavit that shows the past CPS history.
And how do you acquire that information? That affidavit is not yours, correct?
That is correct.
So the information within that affidavit was not acquired by you, correct?
I'm not understanding the question.
So the information within the affidavit isn't yours. So you didn't compile the information for the affidavit, correct?
Correct.
Okay. Where did your knowledge of, I'm sorry, strike that. So you have no personal knowledge of anything that's in the affidavit, is that correct?
Can you rephrase the question?
Your Honor, I object. That's been asked and answered. She doesn't have personal knowledge. She's already said that.
Stay.
Your Honor, given the fact that she doesn't have personal knowledge of anything that she's testifying to right now, I would request that my objection not be overruled. She's testified that she doesn't have personal knowledge of it. And it was, the information that she's testifying to was held within an affidavit that was sworn to by somebody else.
Your Honor, for purposes of for Dear to determine whether or not she's a custodian of records, I don't think the line of questioning was even appropriate. To determine if she's a custodian of records, it's whether or not she has access to the records and has reviewed them, not whether she has personal knowledge. So I don't think the voir dire was even appropriate to determine what Ms. Acosta is doing.
Your Honor, the only document that she's stating that she reviewed was an affidavit with regard to the prior removals. So with regard to any of the information that was acquired to formulate that affidavit and have that affidavit be signed, I would argue she hasn't reviewed it. She just reviewed the affidavit. That was her testimony.
I think that she answered that she did review the affidavit, but I don't think the question was asked if she actually reviewed the case file. And the answer may be that she doesn't know, but until we actually get the understanding of that, I think that needs to be determined from this witness.
Well, the issue revolves around whether or not she's a custodian of the records. And if she's a custodian of the records and she is to the court a trustworthy source of that information, then she can testify as to the contents of the file. And sitting here right now, I've heard enough information to lead me to believe that she is a custodian of the file upon which the department is presenting their case. She has reviewed that information and she's a trustworthy source. So Ms. Acosta, I'll give you another bite at the apple to see if you can bring some doubt into that issue. But as of right now, I believe that the hearsay objection is, I'm going to overrule it based on the fact that she is a custodian of the records.
Your Honor, may I ask her one more question?
Sure.
Ms. Sherrod-Buckner, have you reviewed any other information aside from the one affidavit to that gave you any information about the prior removals?
Yes.
Okay, and where was that information?
I do have access to Impact, and Impact gives us like family history. So when we do run the parent's background for DFPS, it does give us like a detailed list of what those allegations are.
All right, thank you. I'll pass, Judge.
Okay. Then the hearsay objection is overruled. Ms. Fuller, you may continue.
And Ms. Sherrod-Buckner, in regards to the mother, do you feel like you made every effort to attempt her to engage in the services?
Yes, ma'am.
You went over the plan of service with her on more than one occasion, correct?
Correct.
You did all the 2054s that were necessary to set up the services.
That is correct.
And Ms. Hilburn, she had a phone, correct?
Yes.
And as you testified, all her services were virtual, correct?
Correct.
And so, I mean, she did have transportation as well, though.
Yes, from friends.
And so she was able to make it to her visits initially.
Yes, ma'am.
And per your testimony, she did start some of the services, correct?
Yes.
But then she just fell off the map, correct?
That is correct.
And in regard to, were there any requests that from her to switch providers or get any other people involved in her case that maybe she wasn't happy with who she was dealing with, or did she ever indicate that to you?
No, ma'am.
She just stopped going.
That is correct. Even after the service providers have even reached out to her via email.
And the whole goal was, in this case, was family reunification in the beginning, correct?
Yes, ma'am.
But Ms. Hilburn made it very clear to you in your conversations that she would not be able to provide a home to Morgan.
That is correct.
Okay. And so how old is Morgan right now?
I do believe 2024. She'll be 15 this year, I do believe.
Okay, but she's 14 right now.
Yes.
So you're asking the court to terminate Ms. Hilburn's rights so Morgan can be free for adoption.
That is correct.
And do you feel that that's in her best interest?
That is correct.
And has she expressed to you that that's what she wants as well?
Morgan?
Yes.
Yes.
So she has also told you that she wants to be adopted.
That is correct.
And she's in a very good placement right now, correct?
Yes, that is meeting all of her needs.
Okay. But the department will start looking for an adoptive home once the termination is done, correct?
That is correct.
But without terminating Ms. Hilburn's rights, there's not even a possibility of her being adopted.
That is correct.
And then she would end up staying in foster care for the next 4 or 5 years.
That is correct.
And so that would definitely not be in her best interest.
That is correct.
And even though mom attended the visits, and the visits were good. They were they played games, they did certain things. There was never any indication that this child could go home with her mother and be properly taken care of.
Correct.
And the mother was never able to provide you with an address?
Just only the address that she was staying with that friend, but an address of her own, no, ma'am.
And she indicated at one time she was living in a tent in a homeless camp?
Correct.
And that was off and on?
Correct.
Throughout the case? And so it's your request today from the court to terminate her rights, and you feel that it's in Morgan's best interest?
Yes, ma'am.
And you don't think this mother can meet Morgan's needs?
Not at this current time. No, ma'am.
And what level of care is Morgan?
Right now, she's intense.
Okay. And with intense comes a lot of responsibilities with the caretakers, correct?
Yeah.
And she's on medication?
That is correct.
And so do you have any indication that Mrs. Hilburn or Miss Hilburn could meet these needs at all?
Not at this current time. No, ma'am.
I'll pass the witness, Your Honor.
Any further questions for Mr. Rod Buckner?
No, Your Honor.
No, Your Honor.
I'm assuming there's no other witnesses. Anybody planning on calling Casa?
No, Your Honor, thank you.
Do you have any
No,
other,
Your Honor, I would just like to.
do you have any other witnesses or evidence to produce, or it's not witnesses, any other evidence that you want to submit, Ms. Kylie Green?
No, Your Honor, just the exhibits that have already been provided to the court.
Okay. Ms. Acosta, what were you going to say?
I just wanted to address the court, Judge.
All right, I'll let everybody make an argument. We'll start with Ms. Kylie Green.
Thank you, Your Honor. We're requesting termination this afternoon for failure to complete court-ordered services. Ms. Sherrod Buckner has testified both on the 9th of January and today of the efforts that were made by the department and belong to create a family plan of service, the fact that that was ordered by the court, the fact that it had been reviewed with the mother in this case, Ms. Hilburn, multiple times, and that she indicated understanding to these services. There's also evidence that she even began some of the services, which goes against the mother's argument that she was unable due to either technical difficulties or, I don't know, potentially just problems accessing the care. It goes against that argument. She was unable to complete any of the services. She was ordered to do individual counseling, parenting, to obtain stable employment and housing. And the evidence has shown that she did not complete any of those. There was also an indication from Ms. Hilburn that the status quo that she has right now with her daughter is good enough for her. She's not here today. She's not even present here to have Morgan be returned to her. And so while laughing and having fun and having potentially appropriate visits back in June with Morgan, the mother's participation in this case has been on the sidelines this entire time. She's done the bare minimum, if at all. She's maintained contact with Morgan, but to her benefit, not to Morgan's. Morgan needs a mother, someone who can provide and care for her financially, emotionally. It's not just fun and games. And Ms. Hilburn has been unable to provide a safe, stable, and appropriate house for her pretty much through her entire life. So we're asking for termination so that Morgan's desires that have been expressed to be adopted can be achieved. Thank you.
Ms. Acosta?
Your Honor, I would request that the mother's rights not be terminated. I don't believe that there's been enough evidence of best interest presented to warrant the termination. Morgan consistently reaches out to Mrs. Hilburn, which illustrates that she does want to have a relationship with her. And given her age, her level of care, and I haven't heard from anyone that this is what Morgan actually wants. These cases, the Holly factors do still need to be considered, and the desires of the child do still need to be something that the court considers. And I don't think that in a situation like this, where it's potentially not what she wants, that it would be beneficial to her. Thank you.
Ms. Fuller?
Well, Ms. Sherrod Buckner did testify that termination and adoption is what Morgan wants, and I can tell the court that's exactly what she has requested. She would like to be adopted eventually. She's only 14 years old, Your Honor. Staying in foster care, as everyone knows, CPS, Belong, whoever, they are not good parents. And so children need to be with family. They need to be out of foster care. And to not terminate the mom, then Morgan cannot move forward. She is doing well, as Ms. Buckner testified to. She had some incidents, runaway incidents, after she had discussions with her mom. And so that was kind of scary. I mean, she disappeared for 2.5 months in Mexico. And I feel that although the visits were fine, I watched a couple visits and they were fine, but the mother indicated, I cannot take my daughter. And by her total lack of participation, she wasn't even going to attempt to even learn how to take care of her, much less have her come home, and even do visits, like weekend visits, because she didn't complete any of the services, just like she did in the initial case, when Morgan was a young child. She hasn't been a mother to this child for many years, and Morgan deserves to be able to be raised by a family that cares about her and loves her. And Ms. Hilburn has really not made herself available to the service providers, to the caseworker, to anyone to even determine where she lives, or, if she could even have her for a weekend or, a few hours. I mean, everything had to be supervised. So I would ask the court to find that termination is in the best interest of Morgan. I think the factors were proven up. And this is what Morgan wants, Your Honor.
Ms. Roden.
Yes, Your Honor, thank you. CASA is also in agreement and believes that the termination is in the best interest of the child. We don't believe that Ms. Hilburn has shown an ability to parent Morgan now or have any reason to believe that she'd be able to do that in the future. She doesn't have a safe or appropriate home for her, and we are aware of Morgan's desires for adoption. We know that Morgan is 14, and so for some of our youth, that is getting older, but I think Morgan has a specific desire to belong, and I think that if we can't move forward with a relative adoption pretty quickly, we should look at options outside, really talk to her about her plan for adoption and find a family where she can belong. And I think if we don't do termination of the parental rights, we won't have that opportunity in the future. So I do believe it's in the child's best interest.
All right. Ms. Carla Green, could you please put up petitioners 3 for me? I've been able to share a screen.
Yes, Your Honor, if you'll just give me one moment to pull it up.
I'm going to look at 3, and I also want to look at 7, please. And then 11 and 12.
Certified copies I had shown to the court in person.
Right. I do remember that. And I'll put it on the record that when we originally began this trial last week, the court did see certified copies of all the exhibits in person. So we put that on the record. And just make sure Miss Greenwald gets the certified copies, okay?
Yes, Your Honor.
All right, and let me just, for the heck of it, let me see the MSA.
Yes, sir.
All right, based on the evidence presented and the arguments of counsel, court finds that it has jurisdiction over the parties and the subject matter of this case. Court finds that the mother, Miss Misty Hilburn Powell, was served on April the 10th, 2023, according to my records, and has otherwise entered appearance, on April 10th, 2023, and has been at prior proceedings in this case, was aware of this case. Court finds that the father of the child, Paul Ray Hilburn, is deceased. Court finds that Joyce Wetstein, who was previously a managing conservator of the child, that managing conservatorship was terminated by a court order of this court and is in one of the exhibits. The court finds that all parties to which in citation and notice is entitled were duly cited and served or appeared. Court finds that the department has proved by clear and convincing evidence pursuant to chapter 161 161B0010 that the mother failed to comply with the requirements of a service plan created for her and failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of a child. That was the only ground you were seeking, correct?
That's correct, Your Honor.
All right. Court finds that in addition to proving that ground by clear and convincing evidence, the department, it's in the best interest of the child for the mother's rights to be terminated. Court finds that the best interest factors include that the department or belongs goal is to try to get this child adopted. And again, testimony and evidence shows she's only 14 years old and that her desires are to be adopted and that it's not possible for her to be adopted if Miss Hilburn's rights remain intact. So court finds that in addition to that factor, Miss Hilburn is not in a situation now, and the court does not believe she will be in a situation in the future to provide for the child Morgan's needs. She doesn't have the ability at this time to provide her with a safe, stable home. She's not been able to prove to this court, demonstrate to this court that she has that ability. And based on the evidence in front of the court, I do not believe that she will have the ability anytime soon. And this case calls for permanency for this child. So the court finds that, again, it's in the best interest of the child to have Miss Hilburn's rights terminated. Court also, I think I said it already, but makes the finding that the father, Paul Ray Hilburn, is deceased, and that based on the exhibits in this case, no other father has claimed any paternity, and that this is the court of continuing exclusive jurisdiction, and no other court has exclusive jurisdiction of this child. Court finds that the permanency goal of adoption is in the best interest of the child, and her placement is safe and appropriate, meeting her needs in her best interest to continue. The next hearing is going to be a permanency review after final order set for April the 9th, 2024 at 11:30. That's April 9th, 2024 at 11:30. And the court will dismiss Ms. Acosta from her appointment representing the mother and find that she has satisfactorily performed her duties. Court will maintain Ms. Fuller in her appointment as the attorney ad litem. Court names the Department of Family Protective Services / belong as the permanent managing conservator of the child. And of course, the court will keep CASA on as a friend of the court. Anything I failed to address?
Your Honor, I just wanted to say one thing. I think this case was probably one of Ms. Buckner's first cases, and that she tried really hard to engage Ms. Hilburn, you know, and try to get her to get involved with the services. She tried to meet with her. She worked really hard, and she unfortunately had to chase down Morgan on several occasions because she had a period where she was very unstable and running a lot. She's stable now, and Ms. Buckner just brought her for a visit with some other family members, and that was very positive. She was very happy about that. And I want to thank Ms. Buckner for all she's done for Morgan to get this, to, you know, keep her safe. It was a rough case, to be honest, because she disappeared quite a bit.
Well, thank you for that, Ms. Fuller, and thank you, Ms. Sherrod Buckner, for working so hard, trying to engage Mom and then keeping up with Morgan. I do appreciate that. Thank you. Anything else?
No, Your Honor.
Okay. Well, thank you all for your service. See you April 9th, 2024 at 11:30. If nothing further, all parties are excused. And Ms. Kyler Green, if you could stay on. If there's anybody that was on that MTI at the end of the day, please stay on. If not, you're all excused.